Dear students, I have been absent from Ongole due to my preoccupation with some personal work. As such, I am not able to deliver lectures to you on the law of torts. But anyway, I want to put this on the YouTube. So today's subject is assault and battery. Of course, I have to add false imprisonment also. Anyway, because this video will be only for about 8 to 9 minutes, I want to stop with these two subjects. The first subject is assault. The second one is battery. You may be knowing the first one as assault, as I have given the introduction to you also. Assault means show of force which causes a reasonable apprehension in the mind of the plaintiff, that you are going to use the force. Here there are two elements. The first element is there should be some show of force. That means somebody should act intentionally. The second point is that it should cause reasonable apprehension. So the person who is going to receive, in the receiving, he should apprehend. That means he should be of the idea that you are going to use the force. This is the subject of assault. And since it is a very simple thing, you can claim compensation. Of course, you may be knowing the law of torts are very minor offenses, right? So normally, suppose if somebody comes and tries to slap you, is it not? So, but he has not literally slapped. Alage, another, if the person comes and tries to shoot you with a dummy gun, it is assault, right? So do only just posing or giving force or making a show that some act will be committed, it is assault. So please remember the two important case laws. The first case law is Stanley. Of course, we will discuss about battery, but this case law better we will discuss about this one. Stephen versus Myers, that will be better. The first case, Stephen versus Myers. Here what happened is, Stephen is a church chairman. You may be knowing. So there was a meeting in the church. So some developments have taken place. Some angry people. Here the defendant, Meyer, he was angry with the plaintiff. So because of some discussions, and immediately asked the plaintiff to get down from the church, to get down from his seat. But he did not agree. Immediately, the defendant, in a mood of anger, he went there and pushed him from about to pull him from the chair. In the meanwhile, the church warden interfered and subsided the issue. Now here what happened? Just this man showed his angry face and asked him to get down. When he did not get down, he went there and posed as though he was taking away the chair. This is what is called assault, right? The second example, Innis versus Willie. So here it is regarding the police constable. What happened is, so the police constable stood as obstruction to the plaintiff and asked him not to enter the club premises because he was not a member of the club. But this man, the plaintiff, wanted to go to the club. And but what happened? The constable stood like a statue, motionless. He stood like a statue and did not allow him to enter the club premises. Now the plaintiff filed a case of assault, but the court declared that it is not assault because the constable stood like a passive spectator, or he stood like a wall. He did not use any force, he did not make any show of force. That is the assault. These two simple examples are sufficient. So coming to the battery. Battery means, please don't mind, it is an American word. Normally in India we call it as criminal force. Here you have to remember these torts are intentional torts. Normally previously I told you that intention is not an element. Intention, motive, they are not at all necessary for the framing the so-called tort. But here assault means definitely with some intention only you will go and try to slap him. Without intention you will not do anything. So that is intentional tort. So this show of force, and here if the act touches the other person, it is nothing but battery. Or in India we call it as criminal force. In the Indian Penal Code also, according to section 351 IPC, criminal force is defined. Assault is also defined there. So as far as tort law is concerned, So assault means showing of force. Battery means using of force. Here using the force. The second one, with the force, the other person should suffer some injury. Injury means not only physical injury, psychological injury also. But certain incidents, they are not at all batteries. For example, if a boy comes suddenly on your back and thrusts you to divert your attention in a friendly way, it is not battery. Right? But if a person voluntarily pours water on your face, it is battery. Or when you want to sit down on a chair, if he pulls the chair and you fell down, and it is battery. Battery means some action will be there. That action should cause legal injury or harm to the other person. Previous case, let us discuss about one, Innis versus Willie. In that case, the constable obstructed the plaintiff not to go into the club. Right? But here, so this man filed a case of battery. How it is a battery? It is not at all a battery, different, because he did not use any force. Second example, you may be hearing about the symptom voluntary non-fit injuria. That means if you volunteer the injury, then this is a general exception. You might have heard the case law, Stanley versus Powell. In that case, what happened? The plaintiff and others, the defendant others, they went to a pheasant party. That means Nemali. In Telugu we call it as Nemali. They wanted to shoot at the pheasants. Incidentally, when the defendant shot at a pheasant, incidentally it hurt, actually it went to the bark of a tree, and it's called ricochet shot. It came back and hurt the plaintiff. He received injuries. Here he has taken the defense of inevitable accident. Here there is no intention. He did not want to cause any battery to the other person. There is another case called Cherubin Grigori versus State of Bihar. Here what happened is, this state, they were constructing latrines. The defendant was constructing latrines, and he erected a live wire so to avoid the trespassers, so that the trespassers and some persons may not pass along the road. If they pass along the road, he did not put any caution board, as a result of which some persons who trespassed into that area, they were electrocuted. It is definitely amounts to battery. There is another case law, Rixons versus Star City Club. It is a very famous case law, whereas this Rixon has filed a case of assault, battery and false imprisonment also, but nothing was found out. What happened is, this Rixon, he was playing in the Star City Club. Okay, he was declared, I were asked to go out because he become he is having no money, so he was asked to go out. But after going out, once again he wanted to enter the premises. You may be knowing, the bouncers stopped him, they took him to the interview room, and they wanted to tell him that he will not be allowed because he did not have the so-called coins, or he did not have enough money. But he did not agree. So at the interview room, he was kept there. Somebody wanted to put his shoulder on him and asked him to wait, and he wanted to come into the club. So he filed a case. Here, no assault, because they did not show any force. They did not make any show that they are going to beat him. Second is no battery, because they did not actually touch him. They touched him only, they put their hand around his neck and asked him to stop there. Right? False imprisonment means keeping a person unnecessarily in a secluded place for some time. Suppose some three children are playing here. One of them got angry and went out by bolting from outside. So the other persons will say that it is false imprisonment. So you are not allowed to keep the movements of anybody restricted. So tomorrow we'll discuss about the false imprisonment. So with this we stop. So please read the two subjects, assault and battery, carefully. Definitely you will get some questions of 2 marks only. Very simple issues. Please study the subject thoroughly. Thank you.